Jefferson County Code at Law number 2 is now in session. First case that we have is cause number 331716, case of Style of State of Texas versus Ed Alberto Rene Sanchez. Please come forward. Do we have bond conditions in that case? For the record, is your name Ed Alberto Rene Sanchez? Okay, how you doing, Mr. Sanchez? You doing all right? That's good. You don't have any? And the state is represented in this case by Attorney Tommy Coleman. Attorney Coleman, how are you doing?
Good, Your Honor.
Mr. Sanchez, the last time you were here, your case was reset to give you time to hire an attorney.
Yes, sir.
Have you hired your attorney?
No, sir.
Why haven't you hired your attorney?
Because I just represent myself, sir.
You say you want to represent yourself?
Yes.
Okay, now, Mr. Sanchez, there's some paperwork that you need to sign. The first document that you'll be handed is titled Judge's Explanation of Rights to Defendants Without an Attorney. And it reads, and it states, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option?
Mhm.
Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
No, sir. Say it again, please.
If you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
I understand.
And option number three, you may represent yourself. Do you understand that option?
Mhm.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document that I'm reading, that you have before you, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney, then you will place the name of the attorney on the line to the right and your initials on the second line to the left. If your choice is, I want to apply for court-appointed counsel, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will sign the name of the attorney on the line to the right, and you'll place your initials on the line on the fourth line to the left. If your choice is, I want to waive my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will place today's date on the line that's titled date. And today's date is June 22nd, 2022. Okay?
Yes, sir.
Okay, you can go ahead on and make your choice.
I'll be honest, I'm just guilty, sir. I just go represent myself.
Well, you have to, do you need me to read this again to you? Because before we get to what you want to do, you have to make your choice. Okay? Do you need me to explain it to you again? I could explain it to you again if you need me to do that.
Well, I got mentioned again, I'm guilty.
I understand that,
So,
but this document,
I don't have no money to.
well, you have a couple of choices that you can make. I mean, I've just read,
Yes.
for example, it says, if you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. That's what it says in paragraph 2. Now, if we go to the bottom of this document, it says, if you want to apply for court-appointed counsel, then you will place your initials on the 3rd line to the left.
What does
N-
appointed counsel? What does
If
it-
you cannot afford an attorney and you want to apply for an attorney to have one to represent you, you can, that's what it means by court. The court will appoint a lawyer to represent you.
Your Honor, I'm sorry to interrupt. I was a little distracted. Was there an initial inquiry as to how much of any or how well the defendant speaks and understands English?
Do you understand? Seems like, yeah, I haven't had any problem with him understanding. He speaks with an accent. I mean,
Yeah, I understood the question, but last time, you said, sir, that they don't give me no lawyer because this is my second WI. That is why.
who told you that?
I don't know, it was you, I was the judge, I saw the number 3 court.
Well,
That is
only,
why
okay,
the number 3, I want to play a court appointment counsel.
yeah, that doesn't have anything to do with how many DWIs you have.
Okay.
If you
yes.
could have 10 DWIs, that doesn't disqualify you for
Well,
having,
yes.
if you indigent.
Well, that is why I don't.
Okay,
Court number 3.
okay, if you decide, if you want to see if you qualify for court-appointed attorney, then you can place your initials on the line you put your initials on the line that says that.
One more question. So what is hard to hire because I don't know if I have time to meet some people, what just come over here represent myself. What you give me advice?
I can't give you any advice. Okay, only thing I can do is just read to you what's on the form, okay?
Alright, so I just
That's
go-
what lawyers are for. Lawyers could give you advice.
Alright, just sign number 3.
Okay, that's fine. So we're gonna have to give him a financial questionnaire to fill out. You're gonna take a seat. He's gonna give you a clipboard with a pen, and you're gonna fill out that financial form. And once you finish that form, we're gonna ask you to come back up. Okay, so just go take a seat right now. In one of the chairs that have the black and yellow tape in the gallery. Okay, you're welcome. Let's see, this is 22nd.
Yeah. When that- That's why I wanted to say, you write it down, I know this. You put it in here. Just write it in there, Great American. Cookie.
Bradley Deshaun Green, please come forward. Okay, Mr. Green, your full name is Bradley Deshaun Green.
Yes, sir.
This is cause number 331728. Mr. Green, how are you doing?
All right, how you?
I'm doing fine. Thanks for asking. Mr. Green, last time you appeared, you stated that you wanted your case reset to hire an attorney.
Right.
Have you hired your attorney?
No, sir.
And why haven't you?
The only reason I haven't hired an attorney because right after that, I ended up breaking my hand and I've been out of work. We're trying to take care of my bills and everything.
Okay, now, Mr. Bradley. I'm going to go over a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. And it states that now you have three options regarding getting an attorney. Could you give him a judge's explanation of rights? Okay, now I'll go over this document with you and it reads, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
Number three, you may represent yourself. Do you understand that option?
Yes, sir.
If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states defendant's choice, marking issues next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If you've already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If your choice is, if you have already appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant. And you will place the day's date, which is June 22nd, 2022, on the line that is titled date. Do you understand?
Yes, sir.
Okay, you may make your choice. Linda.
Yes, sir.
When our court coordinator comes back in the court, she's gonna reset your case, give you opportunity to hire an attorney. You're gonna stand on that X in front, that second X,
Yes, sir.
and she's gonna come to the windows. But just go stand over there, and once your case is reset, you'll be free to go and you have a blessed day.
You too.
All right. I think we already have. Why don't you get Jennifer, see if Jennifer is available. Jennifer, Roger, the interpreter. All right, thank you. His case has been, he's, want to reset the hire. Right now, Mr. Sanchez, come back up. Mr. Sanchez, are you a citizen of the United States?
Yes.
You are? Okay. That's what I need to know. You just have a seat. We're gonna have Miss Araji to come in. Just that she might be coming in right there. She are, yeah, yeah. Right. Do you have problems understanding English? You don't?
No, just,
Okay.
Under the state would move to maybe, I'd move to ask Mr. Raji out of an abundance of caution to help assist us here, just out of an abundance.
I mean, we have her coming, I mean, but if he has any problems, then she could, you speak Spanish?
yes.
Okay. Okay, just have a seat in one of the chairs with the black and yellow tape. We have anybody ready? Who? You got the paper with them? We need Lawrence. Hillary Lawrence. Okay, thank you.
Appreciate the way you take care of your business.
Court is in session in cause number 331610. The case is styled the state of Texas versus Hillary Marie Lawrence. Miss Lawrence, is that your full name? Miss Lawrence, would you please raise your right hand? Miss Lawrence, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Miss Lawrence, you may put your hand down. How are you doing, Miss Lawrence?
I'm okay.
I'm doing fine. Thanks for asking. Ms. Lawrence, you're here with your attorney, Attorney Kyle Walker. Attorney Walker, how are you doing?
I'm doing good. How are you, Judge?
I'm doing fine. Attorney Walker, do you waive a record in Ms. Lawrence's case?
Yes, sir.
Ms. Lawrence, I have before me a document that was filed by the Jefferson County District Attorney's Office. This document alleges that on or about June 15th of 2017, while you were in Jefferson County, Texas, that you committed. Okay, I see they just refiled it. That you committed the Class B misdemeanor offense of theft. Now, it is further alleged or presented in this information that during the period of March 19th of 2019 until October 7th of 2021, that an information arising from the same set of facts was pending in a court of competent jurisdiction in cause number 322098 in the County Court of Law number 3 of Jefferson County, Texas, and it was styled State of Texas versus Hillary Marie Lawrence. And basically, Ms. Lawrence, what this information is basically saying is that on June 15th, when this offense occurred, apparently that was more than 2 years ago. And this information that we have here was just recently filed. Where is it? Yeah, this information, this document that we have here was recently filed on, let's see, February 24th of 2022. And basically what that is, that's past the 2-year time limit. But the state is, in essence, the statute of limitations would have ran, but the state already had a case this case was already filed against you in County Court at Law number 3, and that stopped the statute of limitations from running. We say, the legal term, we say the statute of limitations was told. It meaning it stopped. And so basically what they're saying is that this is still not outside of the 2-year statute of limitations for it to be filed. Okay? Now, Mr. Walker, you have any objections to this, to her pleading to this information? Okay, now, Ms. Lawrence, to the charge of theft, the Class B theft, which occurred on or about June 15th of 2017, how do you plead? Guilty, not guilty, or no contest? Guilty? Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Yes? Okay. Now, Ms. Lawrence, I also have before me a document that is titled, misdemeanor plea admonishment is also labeled as State's Exhibit Number 1. Ms. Lawrence, do you recognize this document? On page 2 of this same document, Ms. Lawrence, there are a set of initials, HL, on a line that's titled guilty. Did you place your initials on this document? And on the next page of the same document, there's a signature above the line that's titled defendant. Is that your signature? Yes. And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? Yes. Is this your signature above the line that's titled defendant? Yes. There are 2 boxes that are typed at the top, that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? Yeah, that discovery certification. And Ms. Lawrence, I also have before me a document that is titled Discovery Certification. You recognize this document? And is this your signature above the line that's titled Defendant? Now, Ms. Lawrence, before you sign and initial these documents that I've just mentioned to you, did your attorney go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? Ms. Lawrence, are you a citizen of the United States? State, I have before me States Exhibit number 1. State, you like to offer States 1? Any objections?
No objections.
No objections. States Exhibit number 1 will be admitted. Mr. Walker, you advised in counsel, Ms. Lawrence, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Lawrence, your attorney, Mr. Walker, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Lawrence, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Exchange of defendant case, states recommending confinement in Jefferson County Jail for a period of 180 days. However, we're asking the court to suspend the imposition of that jail sentence and place the defendant on community supervision for a period of 12 months, order that she pay a $750 fine, cost of court, perform 60 hours community service restitution, and in addition to the standard conditions of probation that she participate in and successfully complete a moral recognition course and have zero contact with a Quentin Naylor Matthews, and that she be jointly and severally liable for restitution to the Great American Cookie Company in the amount of $682.
Jointly and severally liable.
Yes, Judge, there were two defendants in this case, so my understanding is that the court can order both of these defendants to be both jointly and severally liable.
Yeah, I mean, that's a civil matter.
I've
that-
seen it done in criminal.
Yeah, I'm not gonna find her guilty of a civil offense. Now, if she is required to pay some restitution, you can put the restitution in the judgment.
Well,
but-
the agreed amount of restitution, Judge, is $682.
Okay, so she's gonna pay, she's responsible to pay restitution of $682.
Yes, sir.
And that's to the cookie company.
Yes, sir.
Yeah.
And if no contact with somebody named Quint Teller Matthews.
Yes, sir.
Is that the co-defendant?
Yes, Judge.
I mean, I think in the probation, she's not allowed to, what it says, avoid persons or places of disreputable or harmful character, and especially avoid association with any person previously convicted of a crime or presence at any location where the crime is being committed. It's kind of like it's already in there, but we could put it in there.
Thank you.
Okay, now, Ms. Lawrence, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 12 months. During the 12-month probationary period, you'll be required to pay a fine of $750 plus court costs. The total fine and court costs is $1,102. You'll also be required to pay restitution in the amount of $682 payable to the Great American Cookie Company. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and you'll be required to to reimburse Jefferson County for the court-appointed attorney's fees of $250. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $260. Now, will you be able to pay the $260 each month? You will. Now, Ms. Lawrence, you will also be required to perform 60 hours of community service. You'll be required to attend and complete a moral recognition course. You cannot have any contact with a Quintella Matthews. You will also be required to adhere to the other standard terms and conditions of this probation. And Ms. Lawrence, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Okay, Ms. Lawrence, I'll follow the pre-bargain agreement that you have entered into with the state. Ms. Lawrence, you're gonna stand on the X next to your attorney. You're gonna follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a, right here, next to your attorney. And you'll be free to go, and you have a blessed day. And Mr. Walker, once you sign the paperwork, you'll be free to go as well, and you have a blessed day.
Thank you, Judge.
You're welcome.
I have Peter.
Yeah, I was gonna hurry, get this guy up. He had him before.
He stayed, I told him to stay by.
Okay, yeah, we'll get done. Okay. Add Alberto Rene Sanchez. Okay, this is clause number 331716, case established, add Alberto Sanchez. Mr. Sanchez, would you raise your right hand? Mr. Sanchez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? You swear? Okay, you may put your hand down. Now, Mr. Sanchez, I have two documents before me. The first document that I have is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes.
And is this your signature? He didn't even sign it. Got his initials. He didn't sign it and date it. Where it says defendant's signature at the bottom. And place today's date on there. Well, he didn't sign this one either. He just did his initials right here.
That was his signature.
So,
What do I need to do on this one?
write it. What is it? Which document is he talking about? Do you see where it says defendant's signature? Oh, well, you got, that's your signature?
Yes.
Okay, you get that back to me. He's out on bond. Ed Alberto Sanchez. Pull up his bond. Let me see. We wrote on that. Okay. Okay, now, Mr. Sanchez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes. Sir.
On this document, are these your initials on the line stating you want to waive your right to an attorney and represent yourself?
Yes, sir, that is.
And is this your signature on the line that's titled defendant?
Yes, sir.
Also, I have another document before me. This document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir, I can.
And is this your signature on the line that's titled
Yes.
defendant?
What am I looking for?
Did he, who signed for the bond? Does it have a defendant's signature? I see it right there at the top, right there.
Yeah.
Let me print that off. Let's see what we got. Okay. Show that to him. It is, you got one of those little stickies that have signature on
I got a post-it note here, Jeff.
it? Okay. Okay. Show that to him, where they're supposed to know this. Sanchez, that's a copy of your bond that you're out on? You see that line where it says signature?
Yes, sir.
Is that your signature?
There is, and also my name too.
Well, that's your signature is your
Yeah.
name.
Yeah.
Your initials is just your initials.
Yeah, that's my initial RS.
Right, okay, we need your signatures on these documents. Your name,
And also manager.
yes, that's what signature means, your name. Okay. Okay. Now, Mr. Sanchez. So I use two documents again. One is the judge's explanation of rights of defense by attorney. Is that your signature on the line as title defendant?
Yes.
And your initials on the line that states you're going to apply for, that you would like to waive your right to an attorney and represent yourself. Is that correct? Also, on the waiver of counsel for purposes of entering a guilty plea or proceeding to trial, is this your signature on the line that's title defendant?
Yes,
Now, Mr. Sanchez, before you sign and initial these documents, did you read the documents?
I did.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
very good. I can read it.
Yeah, did you understand it?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
I think they're the best.
Okay. Now, Mr. Sanchez, you stated that you would like to waive your right to an attorney, is that correct? And represent yourself?
Yes.
All right, now, Mr. Sanchez, I need to ask you some questions. And this is pursuant to Ferretta versus California, 422 US 806. Have you ever studied law?
Started with
Yeah, have you ever studied law?
law.
Law, L-A-W.
What is the law?
Okay, so you actually, you probably don't know what it, well, you have never studied law.
No,
All right. Have you ever been represented, have you ever represented yourself in a criminal case?
no.
Do you understand the charges against you?
Yes, I do.
And what are the charges against you?
I have WI alcohol.
Yeah, DWI, it's a DWI second.
Yes, I'm the second.
Okay. Are you aware of the maximum penalties for your charge?
Yes, I do.
Okay, and what's the maximum penalty for your charge? What can you get?
What I can, what I know that I need to pay your and I need to have some community servers.
Okay, that's conditions of probation. Now, the range of punishment is you could be placed in jail anywhere from 3 days, 30 days minimum to a maximum of 365 days, which is 1 year. You could be given a fine from $0 to $4,000. Do you understand that range of punishment?
I do.
Or you could be given both such fine and confinement now. Do you know the exact, use this term, it's called legal elements. Do you know what you have, what the state has to prove to find you guilty in this case?
Repeat the question again.
Do you know what the state of Texas,
Yes,
the
sir.
district attorney's office, what they have to prove in order to find you guilty in this case?
Well, I'm already guilty, so you need to found and I'm guilty.
No, I'm just asking you, listen to my question. Do you know what the state of Texas have to do to prove that you are guilty?
Yes, sir.
And what is that?
But they already has some proof that I'm guilty, so
My question is, what do they have to prove?
I can understand the question, what they have to prove.
Okay, so you don't, in essence, you don't know the elements of the charge. Okay, and what is it? You said you do.
But I have, one more time, I have a DWI that is,
Okay, let me do this. Let me go to the next question. Now, do you realize that if you represent yourself, you are on your own?
yes, I am.
Okay, you want to have a lawyer. Now, as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that?
Yes, I am.
Are you familiar with the Texas rules of evidence and Texas case law?
No, sir.
All right. Do you realize that the Texas rules of evidence and the Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules.
Yes,
Now, for example, do you know how to conduct well, first of all, do you know what a voir dire is?
no, sir.
Okay, it's picking a jury. Do you know how to pick a jury?
Yes,
You know how to pick a jury?
I pick a jury, just hire a jury.
No, you don't hire a jury. A jury is 6 people who would determine whether or not you're guilty or innocent.
Okay,
All right. Now, do you know what are the grounds for excusing a juror, a person who's on the jury?
no, sir.
All right. Do you know what is hearsay?
No,
Do you know what is, well, if you don't know what's hearsay, you probably don't know what are the exceptions to hearsay either. Is that correct?
yeah,
All right. Now, do you know what is the proper way to discredit a witness, or for the term we use is impeaching a witness? Do you know how to do that?
I don't understand the question.
Okay, do you know how to discredit a witness?
Discredit what the worst done.
To find that they shouldn't be believed.
Okay,
Do you know how to do that?
no, sir.
Okay. Do you know what is character evidence and what character evidence and when is character evidence allowed in court or in a case?
No, sir.
Do you know how to make, when and how to make proper objections?
Yes, sir.
You do? Okay.
Yeah, Jackson, that, tell me what is right or not, or something like that, right?
Right, if they're trying to get something in and they violating the rules, right? Okay. Now, do you know how to move for what we call a directed verdict? That means that you're asking the case for the court to acquit you of these charges.
Say that again now.
Do you know, the question is, do you know how to move for a directed verdict? Now, these are legal terms that I'm using.
No, sir.
All right. Do you know how to offer evidence to protect the record for an appeal?
No, sir.
Okay. Do you know the proper grounds for a mistrial?
No,
Okay. Now, are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court. Do you understand that?
No, sir.
Right. Okay, do you know how to request and object to a jury instruction?
No,
All right. Are you familiar with the Texas Rules of Criminal Procedure?
no, sir.
Do you realize that those rules govern the way in which a criminal action is tried in court?
No.
Okay, now, Mr. Sanchez, I must advise you that, in my opinion, you would be better defended by a trained lawyer that you can. Let me see. Okay, well, it's my advice that it is better that you be defended by a trained lawyer than you can be by yourself.
Thank you, sir.
I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with the court procedures. You're not familiar with the rules of evidence. And I would strongly urge you not to try to represent yourself.
Thank you.
Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney?
I just go hire lawyers. So.
Okay, so we're gonna reset his case, give him an opportunity to hire an attorney. You can stand on the X in front of the court coordinator.
Thank you.
Right. Thank you, Ms. Ride. Yes. Okay. Mr. Paul. We have Walter McCoy that's here, is that correct?
Yes, sir.
You got McCoy? Okay.
Thank you. Next one, then.
Okay. Oops. There it is. Court is in session and calls number 331650, case of South State of Texas versus Walter Wendell McCoy Jr. Mr. McCoy, is that your full name?
Yes, sir.
Mr. McCoy, would you please raise your right hand? Mr. McCoy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. McCoy, you may put your hand down. How are you doing, Mr. McCoy? You doing good? Mr. McCoy, you're here represented by your attorney, Attorney Willard Hall. Attorney Hall, how are you doing?
Great. Thank you.
That's good. Mr. Hall, do you waive a record in Mr. McCoy's case?
Yes, sir.
Mr. McCoy, I have before me a document that is titled Information. this information alleges that on or about August 14th of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of boating while intoxicated. Mr. McCoy, do you understand what you've been charged with? And to this charge, Mr. McCoy, how do you plead guilty, not guilty, or no contest? Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Mr. McCoy, I also have before me a document that is titled should be voted, should be like that first. Number 6 of that. 6. Oh, last, let me see, voted, okay. Yeah, it'll be the same thing. I have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. Now, Mr. Hall, I think he's supposed to check that second box that has DWI first. It has the same punishment range down there, the Class B, but the minimum is 72 hours, like DWI first. So you have to check that box,
I'll be happy to do so.
and I'll just.
Just kind of threw me there because. It's a-
Yeah, it's a B, but it's just like the
You can cross it
DWI.
out, make it
Yeah, boating while intoxicated, BWI.
okay.
Okay, thank you. I got it. Okay. Mr. McCoy, I have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. You recognize this document? Now you see the box that's checked, which is it was changed to boating while intoxicated. It had DW, it had driving while it's now it's boating while intoxicated. Okay. On page 2 of the same document, there are a set of initials on a line that is titled guilty. Did you place your initials on this document?
Yes, sir.
And you are pleading guilty to this offense, is that correct?
Yes,
You're pleading guilty freely and voluntarily,
yes, sir.
and you're pleading guilty because you are guilty, is that correct? Now, on page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that is titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, Mr. McCoy, before you sign and initial these documents, did your attorney, Mr. Hall, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Hall, are you a citizen of the United States? Are you a United States citizen?
Yes, sir.
Mr. Hall, well, state, I have before me State's Exhibit number 1. State, you like to offer states 1?
Yes, Judge, state officer states one.
No
In-
objection.
No objection. States exhibit number 1 will be admitted. Mr. Hall, you advised and counseled Mr. McCoy. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. McCoy, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. McCoy, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State. Do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea in this case, the state's recommending that the court defer a finding of guilt and place the defendant on deferred adjudication, probation, or community supervision for a period of 12 months, order that he pay a $500 fine, perform 36 hours of community service restitution, pay cost of court, and in addition to the standard conditions of probation. Yeah, installing a lot. I was hesitant there because we were dealing with a voting while intoxicated, but I think there's a history here that wouldn't, that would tend to support an interlock.
Well, I think it's mandatory anyway.
Yes.
Is it mandatory?
Yeah. Either I did.
What makes it mandatory?
The statute.
On a vote,
It's you can get deferred.
on the defer, okay, yeah, okay.
Yeah, it's mandatory, yeah.
Yes.
Okay. Let's do this. This offense occurred on the, okay, it's after September 1st, 2019. Okay. Now, Mr. McCoy, do you hold a commercial driver's license?
No, sir.
All right. What was, do we know what was his breath test?
It was less than a 0.15, Judge. I don't remember exactly, but it was less.
But it was 0.97. 0.97.
Part 097.
Yeah.
Okay.
Very low.
I was gonna say 0.97.
I'm sorry. I used to say a lot higher.
Okay, then, okay, Mr. McCoy, the state is offering that you serve 12 months deferred adjudicated probation. During the 12-month probationary period, you'll be required to pay a fine of $500 plus court costs of $422, which comes to a total of fine and court costs of $922. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll also be required to pay the DWI education class and the initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, the total monthly installments, that is the total amount that you'll be required to pay each month while you are on probation, is $160 a month. Will you be able to pay the $160 each month?
Yes, sir.
You'll also be required to perform, is that 36 hours of community service. You'll be required to attend and complete a DWI education class. You'll be required to have a drug and alcohol assessment. And you'll be required to install a DWI interlock on any vehicle that you own or operate. Mr. McCoy, you will also be required to adhere to the other standard terms and conditions of this probation. Mr. McCoy, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. McCoy, I would defer finding of guilt, place you on unadjudicated probation for a period of 12 months. Now, Mr. McCoy, if on violation of a condition of deferred adjudication, supervision imposed under Article 42A.104, you may be arrested, detained as provided in Article 42A.751, and you'll be entitled to a hearing limited to the determination by the court of whether the court will proceed with adjudication of guilt on the original choice. The court may not proceed with an adjudication of guilt on the original charge if the court finds that the only evidence supporting the alleged violation of a condition of deferred probation supervision is the uncorroborated results of a polygraph exam. The determination to proceed with adjudication of guilt on the original charge is reviewable in the same manner as a revocation hearing. Now, Mr. McCoy, if you successfully complete the deferred probationary period, this case will be dismissed. It would not appear on your record as a conviction, and you may qualify for a non-disclosure. You can talk to your attorney, Mr. Willard Hall, about the non-disclosure because he's quite competent in those matters. Now, Mr. McCoy, you're going to stand on the X in front of, next to your attorney. You're going to follow the directions of our court coordinator. Once you finish following her directions, you'll be free to go and you have a blessed day. Here you go.
Thank you.
So deferred makes it a requirement for the
Mr. Willard Hall, Mr. Hall. Mr. Hall, yeah, Castaneda, Castaneda. This is cause number 331-638. You're gonna get him on the telephone?
Yes, sir. That has to be good. Hey, Mr. Castaneda, I'm gonna put you on speakerphone and we're in the courtroom with the judge, okay?
Okay, this is cause number 331-638. Case is styled the state of Texas versus Peter Castaneda. Mr. Castaneda is appearing via telephone. Mr. Castaneda, do you hear me?
Yes, sir.
Okay, how are you doing, Mr. Castaneda? I'm doing fine. Mr. Castaneda, you're here represented by your attorney, Mr. Willard Hall, who is present in court. Mr. Hall, what is your announcement in Mr. Castaneda's case?
This is first appearance, Your Honor, and we're still accumulating the discovery,
Okay,
and we'd like to ask for a 60-day reset.
okay, give us a reset date.
August 31st.
Okay, Mr. Castaneda, your case will be reset to August 31st of 2022 for the announcement. Stay in contact with your attorney and your bondsman. They will be given notice of your reset date. Mr. Castaneda, you're free to go, and you have a blessed day. All right, and Mr.
Thank you. I'll be.
Okay, Mr. Hall, you can sign for the reset. Masante Guillory. Stand on the X. Okay, your full name is Masante Cheyenne Tappy Guillory. How you doing, Mr. Guillory?
Okay, how you doing?
I'm doing fine, Mr. Guillory. We have two cases. The first case is cause number 331-550. Second case is cause number 331-556. Mr. Guillory, I see here that you also have a felony case set on August 18th of 2022. Okay, now, Mr. Guillory, have you been to this court before?
Once,
Did we go over the judge's explanation of rights to defendant without an attorney? Where we informed you had three options. You could either hire an attorney, you can apply for a court-appointed attorney, or you can represent yourself. Do we have one in the file?
no, what happened was when I got here, I don't even know if I was arrested.
Okay, so let me do this here. We need to go over that with him. Give him a judge's explanation. Now,
Yes,
Miss-
one.
oh, he has one? Oh.
Printed.
Oh, okay, who was it? Okay, he said he was gonna hire?
August 8th.
Okay, yeah, say you wanted to hire an attorney. Have you hired your attorney? Okay, you need some more time to hire your attorney? Okay, so what we're gonna do, we're gonna reset your case, actually gonna reset your case on the same date of your felony case. So on that date, listen to me, you're gonna come here, check in with our bailiff, let them know that you're here. Then you're gonna go down to criminal district court, which is right next door. Take care of that matter. Once you take care of that matter, then you're gonna come back here to let us know what happened. Now, if you don't show back up, your bond can be forfeited and you could have a warrant issued for your arrest. Okay, so your case is gonna be reset to August 8th of 2022. Stand on the 4X in front of our court coordinator. Once you get to reset, you'll be free to go and you have a blessed day. And who's that? Brogan? Who?
James Herring on page 4.
James Herring?
Judge, August 18th.
That's fine.
Put it on that.
Yeah. Normally, when we have them like that, we open the door.
Okay.
Yeah. Mr. Herring? Come forward. This is cause number 331-756, case of solid state of Texas versus James Donald Herring. Mr. Herring, is that your full name?
Yes, sir.
How are you doing, Mr. Herring?
Very good.
That's good. Now, Mr. Herring, have you been to this court before?
Yes, sir.
Okay, did you get your case reset to hire an attorney?
No, sir. It's just because I didn't have money to pay off my book costs.
Your Honor, my understanding is that Mr. Herring negotiated with another prosecutor pro se for a deal that included paying a $200 fine and court costs of $292. My notes also indicate that the case is reset for him to come up with that amount.
Okay, do you have the fine and court costs? Okay, just have a seat. Make sure we print off his paperwork showing that he has a waiver and a judge's explanation. Just have a seat in the chair that have the black and yellow tape, and someone will come by and talk to you from the DA's office. Is that Rajan Desi? Desi?
Yes, sir.
Yes. Get that door. Court is in session in cause number 331-572, case of solid state of Texas versus Rajan Desi. I'm sorry. Desi? How you doing, Mr. Desi? That's good, Mr. Desi. Would you please raise your right hand? Mr. Desi, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Desi, you may put your hand down. How are you doing, Mr. Desi? That's good. Mr. Desi, you're here represented by your attorney, Attorney David Grove. Attorney Grove, how are you doing?
Good, Judge.
That's good. Mr. Grove, do you waive a record in Mr. Desi's case?
Yes, Your Honor.
Mr. Desi, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. This information alleges that on or about October 24th of 2020, while you're in Jefferson County, Texas, that you committed this Class A misdemeanor offense of prostitution. Do you understand what you've been charged with?
Yes, I do.
And to this charge, Mr. Desi, how do you plead? Guilty, not guilty, or no contest?
No,
Now, you pleading no contest freely and voluntarily?
yes, I have.
And are you pleading no contest because you do not wish to fight or contest the charges? Are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
All right, Mr. Desi, I have before me a document that is titled information. Do you recognize this document?
I do.
I mean, this document actually is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this
I do,
document?
Your Honor.
On page 2 of this same document, Mr. Desi, I have before me a set of initials on a line next to a box that's checked nolo contingere, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of this same document, Mr. Desi, there's a signature above the line that is titled defendant. Is that your signature?
Yes.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, I don't think he put his signature on there. He scratched out the address. Let me show you this out. Now, he scratched out the address.
But did not sign it.
Yeah, you need to sign above that.
Sure. He has a new address, so he just moved.
Okay, thank you. Okay,
We'll get it, Judge.
All right, that's fine. Mr. Desai, I have before me a document that is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, I do, Your Honor.
And is this your signature above the line that is titled Defendant?
Yes, Your Honor.
There are two boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, I do.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, I do.
And I have before me a document that is titled Discovery Certification. Mr. Desai, do you recognize this document?
Yes, I do.
And is this your signature on the line that's titled Defendant? Now, Mr. Desai, before you sign and initial these documents that I've just mentioned to you, did your attorney, Mr. Grove, go over these documents with you?
He has.
And did you read and understand everything in these documents?
Yes, I do.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? State, I have, well, let me do this, Mr. Desai, are you a citizen of the United States?
I am.
Okay. State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1 and
Yes.
State's Exhibit number 2, the proper cause affidavit?
Yes, Your Honor. State offers both states 1 and 2.
No objection to either, Judge.
No objection, State's Exhibit number 1 and 2 are admitted, and the court will take judicial notice of State's Exhibit number 2, which is in the court's file. Mr. Grove, you advised and counseled Mr. Desai. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of.
Mr. Desai, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes, I'm satisfied.
Has he provided full, effective, and competent legal representation?
Yes, he has. Your Honor.
Mr. Desai, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
In exchange for the defendant's plea of no contest in this case, Your Honor, the state's recommending that the court defer a finding of guilt and place this defendant on community supervision for a period of 12 months, or they pay a $1,000 fine, perform 80 hours community service restitution. In addition to the standard conditions of probation, that he participate in the STAR program, have or not download or maintain any dating apps or pornography, and that he subject his cell phone to inspections upon request by the probation department.
Okay. Okay, Mr. Desai. The state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $1,000 for court costs of $307, which counts a total of fine and court costs of $1,307. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. Well, you were hired on this case?
Yes, sir.
Okay. And you will also be required to pay in monthly installments $195. That is, you'll be required to pay $195 each month while you're on probation. Will you be able to pay the $195 each month?
Yes, I will.
You will also be required to perform 80 hours of community service, attend and complete the STAR program. Cannot have no dating apps. You have to permit that your cell phone be inspected by the probation department. And you are not to view any pornography. And you will also be required to adhere to the other standard terms of conditions of this probation. Mr. Desire, do you understand the state's offer?
I do, Your Honor.
Do you think the state's offer in your case is fair and just?
Yes, I do.
And do you accept the state's offer?
I do.
Okay, Mr. Desire, I will defer finding of guilt, place you on deferred adjudicated probation for a period of 1 year with the conditions that you have agreed to with the state, the fine and court costs and the other conditions. Mr. Desire, if you successfully complete this probationary period, the case will be dismissed. It will not appear on your record as a conviction, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent on those matters. You're gonna stand on the X next to your attorney and follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you, Your Honor.
You're welcome.
Judge, permit me to, my case is to go over.
Okay. Hold on a minute. Hold on, let me go ahead on the record. Okay. This is cause number 331052, case of South State of Texas versus Kelly Grogan.
I'm sorry.
Is that, or the Kelly Deontay Grogan?
Yes, sir.
Okay,
That's
Mr. Grogan, how are you doing? I'm doing fine. Mr. Grogan, you're here represented by your attorney, Attorney Langston Adams. Attorney Adams, how you doing?
Doing well, Judge.
Do we have any bond conditions in this?
Yes, he already have it. He has he's in compliance. He has.
I just want to, 331052.
It's on, right?
Oh, you already got it? Okay.
He has everything.
Okay, you're in compliance with your bond conditions?
Mhm.
Okay, now, Mr. Adams, what's your announcement?
Judge, if you don't mind, I just learned today that he got another case. You appointed me on this
Oh, okay.
case. So can you just give me
I
a
wonder why
copy
they
for the
didn't
other
put it in the
case?
same docket.
Like,
Oh,
it's
wait
two
up,
cases.
wait up.
So If
Okay,
you don't mind, can you put me on the other case as well? And I'll try to.
yeah, I mean, you was appointed on this case?
Yeah, I'm appointed on this one.
Okay,
So if you don't mind, then I'll try to work on both of them.
okay, okay, we're gonna wait for our deal is.
And then we can, I understand that that's a family violence too, so I'll get with Mr. Coleman and we can see if we can kind of resolve them both.
Okay, we gotta wait for our coordinator to come back in and our
And then,
deal is.
we can go from
Oh, this is,
there. Now, while we waiting, Judge, what,
that was earlier this month.
right, while we waiting on your, coordinator, one of the requests that he asked me to ask the court, would the court give him some kind of relief on, income monitor? He's telling me he's having to pay $300 a month.
Judge, we'd asked for a hearing on that and notice of, at least 3 days notice on that.
Okay,
I don't mind, I'll give you, that's fine. Can we set a hearing for 3 days notice for,
well, you gotta set it, you gotta file your motion.
I can do that.
Yeah. We just need to reset him for No, he says that,
Mhm.
Mr. Grogan has another case, he said.
Right.
Cameron.
Can y'all just go ahead and point me on that one? That way I can try
Well,
to-
you're gonna be appointed on that one because you're appointed on this one.
Right.
That's automatically done.
Oh, cool.
Yeah,
So they just fax me that one then.
yeah, it's gonna, yeah. They was probably gonna appoint, once they knew about it, that's automatic. Did you, you're gonna have to get his reset. He can have a seat in the jury box, I see. Yeah, just have a seat in the jury box. Just reset him, put him on both of those cases.
Right.
Mhm.
Just reset him for an announcement. Court is in session and calls number 321-124, case style of state of Texas versus Ricky James Elkins. Mr. Elkins, is that your full name?
Sir.
Mr. Elkins, would you please raise your right hand? Mr. do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Mr. Elkins, you may put your hand down. How are you doing, Mr. Elkins?
I'm doing okay. How you, John?
I'm doing fine. Thanks for asking. Mr. Elkins, you're here represented by your attorney, Attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
That's good. Mr. Lawrence, you waive a record in Mr. Elkins' cases?
If I understand what the plea bargain agreement is, Your Honor, yes.
Okay. Mr. Elkins, in cause number 312124, cases styled the state of Texas versus Ricky James Elkins. I have before me the information that was filed by the Jefferson County District Attorney's Office. This information alleges that on or about November 15 of 2018, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespassing. Mr. Elkins, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Elkins, how do you plead? Guilty, not guilty, no contest?
No contest, Your
Now,
Honor.
you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Elkins, I have before me a document that is titled Misdemeanor Plea Admonishments. Mr. Elkins, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Elkins, there's a set of initials, RE on the line that's next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, Mr. Elkins, there's a signature above the line that is titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature above the line that's titled defendant?
Yes, sir, it is.
There are two boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And Mr. Elkins, I also have before me a document that is titled Discovery Certification. Mr. Elkins, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
And Mr. Elkins, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Elkins, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. I also have in the court's file, State's Exhibit number 2, the probable cause affidavit. State, you like to offer State's Exhibits 1 and 2?
Yes, Judge, state offers both states 1 and 2.
Any objections?
None, Your Honor.
No objections. State's Exhibit 1 and 2 will be admitted, and the court will take judicial notice of State's Exhibit number 2, which is in the court's file. Mr. Elkins, your attorney, Mr. Lawrence, is advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Extremely.
Okay, Mr. Lawrence, your client, Mr. Elkins, you have advised and counseled him. Is there any evidence that he is currently mentally incompetent to stand trial?
Oh, no, not at all, Your Honor.
Okay, Mr. Elkins, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea in this case, the state's recommending 3 days confinement in the Jefferson County Jail, and we're asking that the court give the defendant credit for the 3 days that he's already served, essentially making this a time served agreement. And with regard to the companion case, let me back up. As far as the tax and court costs, as far as the court costs and the court costs, we're asking that the court tax and retire the court costs using that jail time.
Right.
And with regard to the companion case, Your Honor, the marijuana case appearing in cause number 324518, we're asking that that case be dismissed pursuant to Chapter 1245 of the Penal Code as part of this plea agreement.
That's correct, Your Honor.
Mr. Elkins,
Yes,
the
sir.
state is offering that you serve 3 days in Jefferson County Jail, but you not have to serve any more time in Jefferson County Jail because you've already served 3 days in Jefferson County Jail. Therefore, you will be given credit if time served. court cost in this case is $337, but you would not have to pay the $337 because the time that you spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. The state will also be dismissing cause number 324518. Mr. Elkins, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Elkins, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Elkins, you're gonna stand on the X next to your attorney and follow the directions of our court clerk. You will be given a copy of your attorney will be given a copy of your dismissal. Once you get your paperwork from the clerk and your attorney, you'll be free to go, and you have a blessed day. And Mr. Lawrence, once you sign the paperwork, you'll be free to go as well.
Thank you.
And you have a blessed day. Mr. Elkins, you can stand on the X next to your attorney. You're gonna stand on the X next to your attorney and follow the directions of our clerk.
Okay, Mr. Alfred, if you don't mind placing your right thumb on his on his sister.
Thank you, Mr. Holmes.
Take care, Mr. Lawrence.
That is it. Thank you for,
Hold on, let's get his,
Oh, dismissal. Hold on.
yeah, get his dismissal.
Did you already sign?
He didn't sign.
We don't need to sign?
No, sir, just the thumbprint. And I got it.
Okay.
But we're waiting on the dismissal, so you're not.
Okay. Did you get his, papers on both cases?
That's what we're waiting on. That's the one to plead on, and then the judge is doing the dismissal now.
All right.
Supplemental, let me get you the actual report. It's a two-pager.
The one that they just mentioned, okay?
Okay, thank you.
Did Ron Cooper appear? Yeah. Okay, this is cause number 323750, case of South the state of Texas versus Ron Omar Cooper. Mr. Cooper, is that your full name? How you doing, Mr. Cooper? That's good, Mr. Cooper. You represented, your attorney of record is attorney Terrence Allison, however, standing in for Mr. Allison's attorney, Marius Allen, who is appearing via Zoom. Does Mr. Allen have your permission to stand in for Mr. Allison?
Yes.
Okay, Mr. Allen, how are you doing?
Good, how are you, Judge?
I'm doing fine. Mr. Allen, what is your announcement in Mr. Cooper's case?
We are waiting discovery, so if we can just get a 8-week reset, and then I'm sure we'll be able to move something then.
Do you have any objections?
No objection, Judge.
Okay, reset it for 60 days. Okay, this case will be reset to August 31st. Mr. Allen, your reset will be sent to you. This will conclude your case. You're free to go and you have a blessed day. And Mr. Cooper, you can get your reset from our court coordinator. Once you get your reset, you'll be free to go as well, and you have a blessed day.
Right here?
Right over there. Yes.
Thank you.
Hold on, Mr. Allen. Mr. Cooper has a question.
I got a call the other day and he asked me what my criminal record was like. And
Well, I mean, I can't, what you need to do, you probably can discuss that with your attorney. Okay?
My
Just
office has reached out to him and tried to schedule a meeting, so we can discuss that then.
Okay, you could discuss it with your attorney. Okay. Stand on the X, for X, get your reset. Once you get your reset, you'll be free to go and you have a blessed day.
All right, thank you.
Thank you. You have a blessed day, Mr. Allen.
You too.
Let's speak, Mr. Chair. Okay. This is cause number 331-756, case of South State of Texas versus James Donald Herring. Mr. Herring, is that your full name?
Yes, sir.
Mr. Herring, would you please raise your right hand? Mr. Herring, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Herring, you may put your hand down. How are you doing, Mr. Herring?
Good.
You doing good? Mr. Herring, I have before me, a couple of documents. The first document I have is titled Judge's Explanation of Rights to Defendants Without an Attorney. Mr. Herring, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials stating that you want to waive your right to an attorney and to represent yourself?
Yes, sir.
Also, Mr. Herring, I have before me a document that is titled Waiver of Counsel for Purpose of Entering a Guilty Plea. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant? Now, Mr. Herring, before you signed and initialed these documents, did you read the document?
Yes.
And did you understand everything that you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Herring, I also have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office owner. And this document alleges that you, James Donald Herring, on or about December 24th of 2021, that you committed the Class B misdemeanor offense of duty on striking structure, fixture, or highway landscaping. Do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Herring, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. Herring, I also have before me a document that is titled Misdemeanor Plea Admonishments. Mr. Herring, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Herring, there are 2 sets of initials. The first set of initials is on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
Now, the second set of initials is on a line that next to a statement that states, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, Mr. Herring, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
And Mr. Herring, on the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, Mr. Herring, before you sign and initialed these documents that I've just mentioned to you, did you read these documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Herring, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer States 1?
Yes, Judge, State Officer States 1.
Mr. Herring, I have before me State's Exhibit number 1. State's Exhibit number 1 is the misdemeanor plea admonishment. That's a document that you acknowledge, that you recognize.
Yes, sir.
And on page 2, this is a document that you acknowledge with your initials on page 2. And you also acknowledge that on page 3 of this document, that this was your signature above the line that's titled Defendant.
Yes, sir.
Now, the state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Oh, and the other thing, Mr. Herring, you have a right to have a record in this case. That is, you have a right to have a court reporter to type down everything that's being said. Do you waive or give up your right to have a record?
Yes.
Okay, now, Mr. Herring, now, State's Exhibit number 1, will be admitted. Mr. Herring, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Mr. Herring, I will accept your plea of no contest. I will find that you are, excuse me, your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waiver were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
Yeah, in exchange for the defendant to plead guilty in this case, Your Honor, the state is recommending a fine only of $200 plus the court cost in this case with 0 jail time.
Okay, Mr. Herring, the state is offering that you pay a $200 fine plus court costs, and the court cost in this case is at least the fine and court costs. Yeah, the fine and court, well, the court cost in this case is $292. So the fine plus court cost is $492. Mr. Herring, will you be able to pay that today?
Yes.
Okay, Mr. Herring, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Herring, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Herring, you're gonna stand on the X in front of our court clerk and follow her, yes, and follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
Yes.
No
Yeah, we don't need, yeah,
disclosure, does he
he
waive-
waived it.
Well, why do we do it with attorneys?
You're right.
Do they not waive their
They don't, there's nothing on there that says they can waive it.
on their paper?
Right.
Okay, I'm giving you 2 copies of the commitment. One, you're gonna turn into the sheriff's office and go and page 192, they're gonna give you a receipt that needs to be done. If you go to the double, give you yours in the block. And then this one's for you. Okay, all right, thank
And
you.
the court is downstairs.
The sheriff's office, you're gonna go down to the sheriff's.
He can tell you what,
Do it.
are you gonna tell him what to do? Okay.
When you go down, when you come in, those doors for the, guard work.
Mr. Lewis, just handed you, well, first of all, this is cause number 33, excuse me. Cause numbers 322, 340, and cause number 332, 334. Both cases are styled the state of Texas versus David Christopher Lewis. Was that your full name?
Yes, sir.
Now, Mr. Lewis, I have the ability to hand you out a document that is titled Standard Bond Conditions in County Code at Law number 2. You see that document?
Yes, sir.
Now, at the top of this document, it reads, following arrest and or accusation in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44A2 and Section C2. Do you understand that?
Yes, sir.
And condition number 3, that doesn't apply to you in this case. However, condition number 4 does apply because you have a DWI, well, you have 2 DWI seconds, and it's referred in the code as a subsequent offense listed under Section 49.04 through 49.06. So because you have a DWI second, this here applies to you. Now, number 4 reads, a defendant who has been arrested or accused of any subsequent offense listed under Section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verifications of such installation being submitted to the court on or before the 10th day after arrest. Actually, we're gonna put the 10th day after today. Let me see your copy. Not. I'll give it after today.
Mr. Holmes, I can speak to you.
Yeah, hold on a minute.
Yes.
Here you go. Now, do you understand that condition?
Yes, sir.
Now, if you violate any one of the conditions of your bond can't be revoked. And if your bond is revoked, you can be, a warrant can be issued for your arrest, and you could be placed in the Jefferson County Jail. Do you understand that? Okay, now, Mr. Lewis, before you do that, I need to just put something on the record. Mr. Lewis, I think about a month or 2 ago, did I see you at Big John's?
Yes, sir.
Okay, did you approach me stating that you knew a relative of mine? Is that correct?
Yes, sir. We surround our, we work together.
Right, right. Now, state, I'm putting state on notice that he did approach me. Now, did we talk about your case?
Yes, sir.
Okay. Now, state, the court is willing to recuse itself if the state, not the state believes that there's an appearance of impropriety or any conflict of interest in this case.
Not at all, Your Honor. So long as the merits of the case were not discussed and the court feels like it can be impartial, the state has no objection to it.
Okay. Now, Mr. Lewis, you are represented by your attorney, Miss Stella Morrison. Ms. Morrison is not here. And so I'm not going to talk to you about anything. You need to, whatever you need to say, you need to first run that by your attorney.
It's hard to get in touch with my
Okay.
attorney in time.
Okay, I understand, but I can't talk to you about your case outside the presence of your lawyer. Okay? So at this time, your case, now I do know, and we'll go off the record on this here.